she was slapped in court. Seconds later, she took the judge's seat. The morning began with the kind of quiet that makes footsteps sound like decisions. A black woman in a neat blazer, hair pulled back, carried a leather case up the courthouse steps. She paused beneath the stone cornice and glanced at the bronze plaque that named the building's heart, Courtroom 3, Justice with Dignity. She exhaled once, as if placing a promise under her breath, and moved toward the entrance. 2 uniformed officers blocked her path. The taller one, Officer Kane, looked her up and down the way some people read a headline they think they already understand. "Where's your pass?" he asked, voice flat, hand hovering near his belt. She offered her lanyard, an access card clipped behind her blazer. Kane didn't look. He cocked his head toward the smaller Officer Weller, who folded his arms and smirked. "Mom, you're in a restricted approach lane," Weller said. "Back around to public screening." "It's 8:45, she replied, calm but firm. "I'm due in chambers before 9. My access is authorized." She held out the card again. Kane swatted her hand aside. The leather case slipped, papers whispering against each other as they slid inside. "Step back," Kane ordered, closing the distance. "Hands where I can see them." She didn't flinch. "Officer, look at the card." What happened next took less than a second and changed everything. Kane's open palm struck her cheek with a crack so sharp the pigeons on the eaves startled into flight. The woman's head snapped to the side. The leather case fell. Her knees didn't. She steadied herself against the stone, eyes stunned but not broken, as Weller grabbed her wrist and yanked it behind her back. Metal kissed skin with that cold, officious click, one cuff, then the other. People at the security line went silent. A clerk with a coffee cup halted mid-sip. Somewhere a phone camera rose, then lowered again, fear tugging at curiosity. Kane leaned in close, voice low and contemptuous. "This is a courthouse, not a shortcut. Learn the rules." The woman swallowed, jaw tight against a rising ache. She looked up at the hall beyond the metal detectors, where portraits of past judges lined the walls, stiff collars, stern expressions, oil and heritage. One portrait farther down showed a woman about her age with a soft steel in her eyes. It could have been a mirror if time and paint were kinder. They marched her through, no Miranda, no explanation, just the dragging rhythm of authority, sure it would be believed. In the courtroom, a visiting judge, Judge Harrow, a gray-haired stand and covering a full docket, took the bench. The woman was led to the defendant's chair, wrists chained to each other, and to a loop at the table, an indignity designed to be seen. "State your name," the clerk said. The woman studied the room, bailiff at parade rest, stenographer poised, prosecutor checking notes, public benches half filled with cases waiting to be called. When she finally spoke, it was measured, as if each word had been weighed against consequence. "My name is irrelevant until I'm allowed to speak with counsel. I request medical attention and the preservation of all surveillance footage from 8:45 to 9:15 this morning." Kane adjusted his tie and stepped into the witness box. He'd done this before. The pattern fit like an old uniform. "Your Honor, the defendant was loitering in a restricted zone, refused commands, became agitated, and resisted protective custody." "Protective," the woman echoed faintly, more to herself than to the room. "She also carried documents appearing to be confidential," the prosecutor added smoothly. "We suspect intent to impersonate staff." "Do you have body cam?" Judge Harrow asked. "Malfunction," Kane said without missing a beat. "However, we have partial cell phone footage showing the defendant escalating." The hook deepened with each comfortable lie. People in the gallery nodded in the way of those who have heard this story before and found relief in its familiarity. The woman closed her eyes a moment, not in defeat, but in summoning. When she opened them, something in the room tilted a tiny recalibration like a compass needle finding true north despite the magnets pressed against it. "Your Honor," she said clearly, "before this goes further, I request a brief recess to obtain identification for my secure office. Additionally, I ask the court to order immediate preservation of courthouse entryway footage, including camera 7 at the main steps and the access control logs for this lane." Judge Harrow frowned. He hadn't expected the cadence of a professional. He hadn't expected statutes cited without bravado. "On what basis do you make these requests?" "On the basis that truth often hides where pride refuses to look," she replied. "And because actions have consequences, especially when recorded." It was the first surprising moment in a day that was about to set records for them. The judge granted a 10-minute recess routine, harmless, paperwork-friendly. The bailiff escorted the woman to a holding room. Kane leaned back in his chair, casual, victorious, already shaping his summary for the report. He never saw the pivot coming. The people who did would later describe it as the precise second a hush turned into history. When court reconvened, the bailiff's voice carried a new steel. "All rise." The gallery complied in a clatter of benches and shuffled programs. The door behind the bench opened, and the woman walked in, no cuffs, no blazer now, but in full judicial robes trimmed with subtle gold piping. She moved with the measured composure of someone who knows exactly how far her voice will carry in a room like this. She took the bench. Not a guest spot. Not a borrowed authority. Her bench. Kane's smirk died so fast it left a shadow. Weller's mouth fell open. The sound that escaped him was the opposite of words. Judge Harrow, who had been warming the seat as a courtesy to the docket, stepped aside in a confusion that looked almost like escape. The woman, now unmistakably Judge Naomi Ellison, settled the robe at her shoulders and lifted the gavel. It wasn't theatrical. It was the simple reclaiming of a tool. "Court is now in session," the bailiff announced, voice a shade fuller than before. The Honorable Judge Naomi Ellison presiding. Judge Ellison's eyes swept the courtroom. People shifted under the weight of being seen. "Officer Kane," she said, voice level. Remained standing. He jolted to his feet like a man waking in the wrong dream. "Moments ago, while I was escorted to chambers, the Chief Judge's office retrieved and preserved the courthouse security footage covering the main steps and the restricted lane. We also recovered automatic cloud backups from your body camera, which uploads telemetry and video at 60-second intervals even during malfunctions." A ripple went through the room, shock, curiosity, dawning memory of policies signed without reading them. Kane's hands curled on the railing of the witness box. Judge Ellison met his eyes. "Before we review what those systems show, I'll place one fact on the record. I have held this bench for 15 years. I was walking into my workplace with my valid credentials at 8:45 this morning. You struck me without cause." Gasps broke from the back row, the way thunder breaks ground it doesn't intend to. The stenographer looked up despite herself. Even the clock on the wall seemed to tick louder in protest. Kane swallowed. "Your Honor, I didn't recognize." "That much is apparent," Judge Ellison said, not unkindly but without an inch of give. "Recognition is not the standard. Law is." She tapped a tablet. The courtroom screens flickered to life with security footage. There was the entrance, the sun breaking against stone, a steady stream of citizens. There was Judge Ellison attempting to present her card. There was Kane, hand knocking hers aside. The slap erupted in pixels and shame, the kind of moment a city pretends it forgot until it sees it again and remembers where it stored the memory. The room didn't breathe for the duration of the clip. When it ended, Judge Ellison switched feeds. Bodycam metadata scrolled. Device IDGPS upload ping. The malfunction had dutifully uploaded audio snippets and frames. Enough. More than enough. "Officer," she said softly, "do you wish to amend your earlier testimony?" Kane's jaw worked. Language had abandoned him. He looked at Weller, who looked at the floor, which offered no help. The prosecutor cleared her throat, papers suddenly heavier than casebooks. Judge Ellison folded her hands. "This court will recess for 20 minutes to permit the district attorney's office to confer with the Attorney General and the U.S. Attorney regarding appropriate charging decisions. Bailiff, ensure Officer Kane and Officer Weller remain in this courtroom under supervision. Any attempt to leave will be considered contempt." Her gavel fell once. The sound was not loud so much as exact. It found the places in the room where arrogance had pooled and scattered it. In chambers, staff moved with fast, focused efficiency. The chief judge arrived in a rush of quiet authority. 2 investigators from internal affairs took seats near the back, waiting for the signal that the ordinary day had ended. Messages flew. Preserve this, notify that, seal that hallway, retrieve those logs. The courthouse, so often a building of endings, had never felt more like a beginning. When court resumed, it was standing room only. Word travels quickly when respect is about to be taught in public. Judge Ellison looked out at them all. "We will proceed carefully," she said. "This is not a spectacle. It is a test of whether our system can correct itself in daylight. She turned to Kane. "Officer, you once told a defendant that actions have consequences. You were right. Today, those consequences are yours. The law does not confuse a uniform with the truth. Investigations are rarely cinematic. They move in paperwork and patience. But sometimes, when the right files meet the right daylight, they unfold like a symphony everyone thought was noise until the melody clarifies." The Attorney General's liaison appeared first, flanked by two career prosecutors who wore the look of people who have carried heavy boxes into many rooms. They presented a thin stack of forms that were thicker than they looked: authorizations, preservation orders, and an initial intent to pursue charges pending full review. Judge Ellison nodded, marked them as received. "Place copies on the record." Then she turned to the visiting judge. "Thank you, Judge Harrow, for your assistance this morning. Your docket will be reassigned temporarily. I'll retain this matter until an independent tribunal is constituted. Transparency demands it." Harrow bowed his head, relief and professional humility making a quiet alliance. The first surprise witness wasn't a witness at all, but a policy document. The courthouse's access control system, long treated as a sleepy badge reader, had a log. It showed Judge Ellison's card pinging the secure lane at 8:44 with a green validation and an open command to the turnstile. Photographs embedded in the log displayed her credentials, her face, a timestamp laid over pixels like the hand of the clock itself. No malfunction there. Then came the clips. Not a compilation meant to shame or entertain, but a surgical presentation, 5-second slices that told a long story. In them, Kane's voice suggested attitude where none existed. Hands being raised to shield from light were described as threatening. Requests to read rights were reframed as verbal escalation. Weller's laughter appeared in 3 separate clips when citizens asked to file complaints. Judge Ellison did not let the room revel. "We are not here to discuss character," she said. "We are here to examine conduct, not just today's, but a pattern that suggests today was not an aberration." She signaled to a young assistant from the chief judge's office who wheeled in a cart of files, complaints that had been stamped, logged, and sent into the archival deserts where such papers often go to fade. "These are prior reports," she explained. Several were closed as unsubstantiated without review of available video. That changes now. A public defender in the gallery covered her mouth with her hand. A prosecutor on the aisle stared at the ceiling as if math had grown personal. Judge Ellison invited a data analyst, a quiet man with the posture of someone who has learned the courage of numbers, to the front. He spoke of arrest rates and force reports with the kind of careful neutrality that can still break a heart. "The datasets suggest significant disparities," he said. "These are not isolated anomalies." "English, please," someone muttered. In plain terms, he translated, too many encounters ended badly for the same kinds of people for the same vague reasons. The numbers alone don't convict anyone. They do demand we stop pretending not to see. Kane shifted in his seat like the chair had sprouted thorns. Weller stared at a scuff on the floor until it became a landscape he could get lost in. Then came the human voices. Mrs. Alvarez, a nurse, testified that she'd been cuffed for asking which line to stand in when she was late for a shift. "He told me to stop acting like I belonged," she said, hands trembling, voice steady. "I was wearing my hospital badge." He laughed. Mr. Reed, a warehouse supervisor with a slight stoop from years of lifting more than he should, described how a routine entry turned into a detention when he didn't understand a command barked while he was taking off headphones. "By the time I pulled one earbud out," he said, "it was too late to be right." A teenage boy, now 18, then 16, described being walked out in cuffs for filming a friend's detention from across the street. "They said I was interfering," he whispered. "I was standing on the sidewalk." The room listened to his quiet, like it was a sermon. Each time, Judge Ellison reminded the room, "We are not convicting from the bench of public opinion. We are collecting truth." By midday, the line between what Kane had said and what the cameras had shown was no longer a line. It was a gulf. The prosecutor, who had begun the day confident in well-traveled narratives, now requested a recess to prepare formal charges. The Attorney General's liaison whispered with the U.S. Attorney's representative in the back row. Alliances were being rearranged in real time. Before the break, Judge Ellison addressed the officers directly. "You are entitled to counsel. You will have it. You are entitled to your full rights. You will receive them. You are also entitled to tell the truth. Begin there. Kane's lips parted around a dozen rehearsed sentences. None survived the gravity of the room. Afternoon sunlight tilted through the high windows, laying gold on wood. It made the courtroom look kinder than it felt. The human cost of procedure had begun to surface, and with it came the deep, complicated emotions that belong to any city brave enough to look at itself without blinking. Officer Weller asked to speak first. He'd retained a union lawyer who'd told him to say nothing, but something about the morning had cracked the shell of certainty. "I follow the lead," he said, voice small, eyes on his hands. "I thought it was how things were done. I never questioned why someone's ID was never good enough if their face made us suspicious." "Suspicion isn't policy," Judge Ellison replied. "It's a feeling. Feelings don't trump rights." He nodded, a tear drawing a clean line through the dust of his courage. Kane's attorney stood, calm and seasoned. "My client exercises his right against self-incrimination," she said. "It was her job, and she did it well." Kane stared forward like a man watching his reflection in glass grow older by the minute. "Very well," Judge Ellison said. "Your rights are preserved." The next witness was Officer Jenna Park, same precinct, same uniform, different record. Her file thin and clean, read like the city's better self. "I've worked with Officers Kane and Weller," she admitted. "I've observed methods I disagreed with. I filed internal concerns. They went nowhere." "Why?" Judge Ellison asked. "Because complaints became rumors, and rumors became warnings. Don't be that cop who writes up other cops." "And I was new. New gets quiet." Judge Ellison held Park's gaze. "Thank you for choosing not to be quiet anymore." An internal affairs captain followed, face carved by years of impossible balances. He described understaffed review boards, mountains of footage, the triage that turned patterns into isolated incidents because there weren't enough eyes to see the whole. "It isn't an excuse," he said, preempting judgment. "It is, in part, an explanation." "Explanations are the beginning of change," Judge Ellison said. "Not the end." The room, having reached its emotional high tide, shifted toward purpose. Community leaders spoke not just of anger but of proposals, bias reporting portals with independent oversight, automatic appeals for cases built on officers with flagged patterns, training designed by people who had lived on the other end of the badge, and a standing monthly forum where the courthouse opened its doors to listen, not lecture. "You can't fix trust with a press release," said Ms. Carter, a high school principal who had calmed more corridors than most chiefs. "You fix it with a calendar and a chair." Kane, through his attorney, finally spoke without speaking. He submitted a written statement acknowledging procedural errors. It was thin as paper and cut about as deep. But even paper can become part of a record that moves mountains later. As afternoon bent toward evening, Judge Ellison announced preliminary decisions. "Based on today's evidence, I am referring Officers Kane and Weller for criminal charging decisions to the Attorney General, with parallel referral to the U.S. Attorney's Office for potential civil rights violations. The District Attorney will conduct an independent review of cases in which these officers' testimony was material. Any defendant currently in custody on such a case will have an expedited bail review." She let that last sentence sit, because freedom sometimes comes in sentences that don't look dramatic until a family hears them. "And to the people who came forward today," she added, voice thickening at the edges, "you have done more than accuse. You have asked us to be worthy of the robes and the badges we wear. Hold us to it. Hold me to it." A week later, the courthouse convened a special tribunal, independent, public, and built with guardrails that would outlast news cycles. Judge Ellison sat as presiding officer, joined by a retired justice and a community mediator whose slow nod could quiet a room. The first order of business was structural. "We will pilot an automatic transparency protocol," Judge Ellison announced. "Body cam uploads will be mirrored to an independent repository within 60 seconds, unavailable for deletion by the originating department. Access control logs will be cross-checked weekly by a non-law enforcement auditor. Any officer with 3 or more sustained complaints in a 12-month period will trigger a mandatory external review of all arrests and testimonies during that period." A murmur, half relief, half the fear that attends real change, rolled through the benches. The gavel fell. For once, the sound didn't end something. It began something harder. Then came accountability. Charges were read aloud, not like a drumbeat, but like an inventory: assault under color of law, false statements, interference with access to public facilities. Each count was explained in plain English. Every person in the room, whether lawyer or layperson, could follow the map from conduct to consequence. Officer Weller, armed with remorse and counsel, entered a plea agreement, cooperation in ongoing investigations, permanent decertification, restorative justice participation with individuals he had detained, and a public apology delivered in the same room where his silence had once stood taller. Then, his voice. There were sniffles when he spoke. It didn't fix the past. It did change his place in the future. Officer Kane pled not guilty and requested a jury trial. The tribunal's role was not to convict him. That would come later, in a courtroom with instructions and 12 citizens. The tribunal's role was to ensure the system that would judge him had doors that did not stick for certain people. During a break, a young man approached Judge Ellison in the hallway, had clutched like a shield. "Mom," he said, "my mother always told me be respectful, be careful, be small. Today, watching you, I felt like I didn't have to be small to be safe." Judge Ellison smiled softly. "The goal isn't to make people small," she said. "It's to make the system big enough for all of us." That evening, the courthouse lights burned late. Teams combed through cases linked to Kane and Weller, flagging those that smelled of haste or bias. Prosecutors wrote letters that tasted like humility. Public defenders drafted motions that sounded like relief. Judges, some older, some newly appointed, gathered around tables to discuss a calendar of reforms. The building that had carried so many verdicts felt, for once, like it was reaching for one about itself. On the day of sentencing for a separate officer in a parallel case that had risen in the wake of this one, security lines moved quietly. People looked one another in the eye a fraction longer. Respect, when it arrives, is almost courtly. It steps forward without hurry so everyone can see what it looks like. Judge Ellison entered through the chamber door, robe catching the light. The bruise from that first morning long faded. In its place was something brighter and far more durable, the knowledge that she had not used the bench only as a seat, but as a standard. Before calling the docket, she spoke to the room and, by design, to the city beyond it. "What we lived through together began with a slap and a set of assumptions," she said. It continued with a lie repeated in a tone that expected to be believed. It turned when a camera told the truth and a community refused to look away. It will endure because we decided that dignity is not a courtesy granted by power, but a right carried by every person who walks through these doors. She looked at the defense table where Weller sat in the audience, no longer an officer, eyes red but resolute. Nearby, Officer Park nodded once, the dignified salute of a colleague who had bet on integrity and won something better than comfort. In the back, Mrs. Alvarez held her hospital badge and smiled through tears that tasted a little like justice. "In this courtroom," Judge Ellison continued, "we will not belittle a person because their title isn't visible. We will not presume guilt because skin suggests a story to lazy minds. We will not confuse a uniform with righteousness or a robe with perfection. We will listen. We will verify. We will correct." She eyed the seal on the wall, blindfolded Lady Justice, scales level. Respect is not a favor. Humility is not weakness. Kindness is not naivete. These are the disciplines that make power safe in human hands. Then, the payoff every viewer waits for, delivered not as spectacle but as a covenant to anyone who has been underestimated. I say this, your value isn't decided by who fails to recognize it. To anyone who wields authority, I say this, your honor is measurable by how gently you use it. And to those who watched a black woman be slapped at the courthouse steps and then watched her take this seat, I say this, justice is not a fantasy. It is a practice. Practice it with me. The gavel touched wood, not thunder. A heartbeat. Outside, cameras gathered for the ending that felt like a beginning. Reporters asked if the system was finally fair. Judge Ellison didn't pretend perfection. "We built new doors," she said. "Now we keep them open." A teenage boy from the first day no longer whispering spoke into a microphone with a steadier voice. "I used to think the rules were a wall," he said. "Today, they feel like a bridge." In a precinct across town, a training class watched the footage and the reforms in a presentation titled simply, "What Respect Looks Like." Officer Park led the discussion. No one scrolled their phones. When she finished, a recruit raised a hand. "If I forget," he asked, "what's one thing to remember on the street?" Park didn't hesitate. Ask yourself if you're protecting dignity along with safety. If the answer is no, stop and start again. Back at the courthouse, the last file of the afternoon slid into a cabinet that no longer hid complaints, but curated corrections. The sun dropped to the edge of the building where promises catch and glow before they become evening. A janitor who had watched more justice than most judges locked up for the night and paused beneath the portrait in the lobby, the one whose eyes held soft steel. He tipped his cap. "Good work today, Your Honor," he said to no one and to everyone, then stepped into the cooling air. Justice did not float from the rafters. It walked out the front door on 100 pairs of feet, some in boots, some in heels, some in worn sneakers. It would return in the morning, expecting company.